Welcome to the Block and Tackle Show, hosted by Carl Block. Carl is a partner in the law firm of Loeb & Loeb here in Los Angeles, California. He will be tackling some of the biggest issues in business today. Listen, learn, and enjoy as he leaves no stone unturned during deep conversations with some of today's most amazing business leaders. Welcome to the show.
Welcome to today's episode of the Block and Tackle Show. Today, I'm very pleased to have a very distinguished guest, a man who is a professional arbitrator whose background is litigation, Mr. Dan Platt. Dan has litigated cases in courts throughout the United States. He has worked in several very prestigious law firms and also a national law firm. And he has also litigated hundreds of arbitrations and participated in many, many mediations. So frankly, in terms of somebody who's been on the opposite side of the table with an arbitrator or mediator, there are few people with the experience that Dan has had. Dan, welcome to the show.
Thanks for having me, Carl.
My pleasure. And so today, based upon your experience, I'd love to talk to you about arbitration and mediation, recognizing that there's going to be a lot of people watching this podcast who aren't trial lawyers or aren't litigators, and they probably don't know a lot about arbitration or mediation. However, as you know, both of them are very effective alternative dispute resolution tools. So, Dan, really, really a pleasure to have you, and thanks for coming.
Of course, my pleasure.
Okay, so now maybe we should first talk about what arbitration is. So, as you would describe it, please tell our audience, what is arbitration?
Sure, that's a great initial question and a great place to launch the discussion. Arbitration is essentially a contractual agreement to litigate any dispute outside of the court system. There's a lot of flavors of different types of arbitration provisions that we can talk about, but basically the parties are agreeing that an arbitrator, such as myself or another arbitrator or a panel of arbitrators, get to decide the issues instead of a judge. And the question that a lot of non-lawyers have is, so what? What happens once you have an arbitration? And what happens is there's both federal and state statutes that permit the party that prevailed in an arbitration to take that order to a state or federal court and have it converted into a conventional judgment that everybody is familiar with. Whether it's for monetary damages or non-monetary damages, you can ultimately end up with the same relief you would get in court without having to go through the court system.
Well, that sounds like a fantastic tool. So, Dan, what kinds of disputes can be arbitrated?
So there's really no limit as to what can be arbitrated, but in order to get into arbitration, there needs to be a contractual agreement to do so. So absent a contract, you're not going to get into arbitration. But once you're there, depending on the language of the arbitration provision, it can include the breach of contract claims, which may come into play, or anything else. It all depends on what the authors of the provision decide it should include.
Okay. And I would imagine that because of that type of situation, there's no jury trial?
That's a great question, Carl. That is correct. And it's particularly important to know that in California, a contractual provision to waive a jury is unenforceable, but an arbitration provision is enforceable. So if the parties decide that they do not want a jury, arbitration is really the only way you can contractually agree that a dispute will be decided by somebody other than a jury, i.e. an arbitrator or a panel of arbitrators.
Okay, so you have been a very experienced litigator, and as you know, I'm not. There's something in the court rules that a lawsuit is filed, and correct me, and then somebody can request a jury trial or not, and if you don't post the jury fees, there's no jury trial. But otherwise, if you do post the jury fees and it's a legal issue, you'd get a jury trial in the superior court. But with arbitration, you know from the beginning, there's no jury. There's no later, let's see if somebody posts the jury fees, etc. Does that sound right?
From 30,000 feet, that is correct. There's a lot of complicating factors with state court. For example, there are some claims that don't go to a jury to begin with, such as an equitable claim or a claim for declaratory relief on a contract as to the meaning of a contractual term and many other things. But you are right that because it is up to the parties to request a jury when they have a right to it, you don't know necessarily at the front end if a party will request a jury. You do know with certainty in an arbitration that there will not be a jury by definition.
Okay, and that's important. Now, juries or even court cases without juries, they're in a courtroom, they're in a courthouse. In theory, anybody can walk into that courtroom and watch the case. That's not the case with arbitrations, is it?
That's correct. So you are right that courtrooms are open to the public absent extraordinary circumstances, especially in civil cases. Occasionally, there's aspects of it that are confidential and the courtroom will be closed, but it's rare. Arbitrations are typically done in a conference room at the arbitration provider's offices, or done virtually, or done in a hybrid setting and maintain their confidentiality. Now, there's an important distinction to make here that I think might be your next question, which is in a court case, unless something is filed under seal, the public can access the file and look at anything that's been publicly filed. In an arbitration, the docket is not available to the general public. That doesn't mean that the documents are necessarily confidential and can't be subpoenaed or things of that nature, but the actual court file is not available to the public.
Okay, and not to make too fine a point of this, even though it's an important point, it's pretty hard to get things sealed in court. If somebody files something, you have to go through this whole procedure, and it isn't necessarily easy, is it?
That's right. It can be complicated, and even if the parties stipulate to file something under seal, the judge may still reject it. It is a complicated and expensive procedure.
Okay, and arbitration, you know from the beginning, for the most part, people aren't going to know about the process, and you may have litigants who just don't want people to know that they're in arbitration, and they don't want people to know what the disputes are, what literally is being litigated in the arbitration, right?
That is correct. It is confidential in the sense that there is no public record of it. But just because something happens in an arbitration doesn't mean it's completely confidential, in that if somebody's aware of a case or of documents that exist, those records could be subpoenaed.
Sure. And I mean, I understand that you can try to designate the entire proceeding as confidential in an arbitration agreement. But as you're saying, if there's underlying documents that were introduced in the arbitration, those could be subpoenaed?
Correct. Not necessarily from the arbitration service, but from the parties if somebody's aware of them.
Sure. Okay. So we know that it's confidential. We know that there's no jury trial. What are some of the other advantages to being in arbitration?
Well, the list is endless in the sense that it's only limited by the creativity of the lawyers that draft the provisions. Mm-hmm. For example, you could require that the arbitrator have specific expertise or a specific number of years of experience. You could choose to have more than one arbitrator. It's very common to have a panel of 3. It's also fairly common to have each side pick an arbitrator, and those 2 arbitrators pick a third, who's the chair of the arbitration panel. And they're at the end of the hearing, the 3 panelists vote almost like jurors, and the chair drafts the award typically. You can limit how much discovery the parties are entitled to. You could expand the types of discovery they're entitled to. You could limit the types of damages the party's entitled to. For example, you could say that if in a breach of contract case, you're entitled to your actual damages, but not consequential damages, which would mean anything triggered by a breach. There really is no limit as to what you can include, as long as it's fairly negotiated and the parties agree to it.
Okay, so let's revisit some of the creativity in a minute, but going back to, the selection of the arbitrator, people may or may not know, who are lay people, that particularly when you have a court of general jurisdiction, I believe the term would be, you have a trial judge who hears criminal cases and civil cases. And that in those civil cases, they could hear personal injury, they could have really simple breach of contract, vendor supplier disputes. You could have very complicated corporate issues. You could have many, many, many kinds of issues in front of the judge. But that's not really up to the judge what the judge litigates. It's what cases are being filed and assigned to the judge through whatever the system is. Is that correct?
Well, that's correct. The judges are picked randomly for each case, and every courthouse does it differently. And they can get any case that comes in the courthouse, civil, criminal, any type of civil or criminal, and there's no control over that. When you select an arbitrator, for example, you could select an arbitrator who has, if it was a tech case, who has software engineering expertise, or perhaps you want to pick a retired judge, or you want to pick an arbitrator who's got at least 10 years experience litigating healthcare cases or real estate cases. So you get a little bit more control, which sort of dovetails, if I'm not getting ahead of myself, Carl, into how the entity that I work for, JAMS, and other entities select who the candidates are in order to have the parties select an arbitrator. And the way it works generally is if the arbitration provision calls for example, a lawyer with at least 10 years experience handling commercial real estate disputes, the arbitration provider provides the parties with lists of potential arbitrators, and they get to strike a certain number of arbitrators and rank the remaining ones, and then the highest ranked arbitrator typically gets selected. Different organizations have slightly different takes on the process, but that's generally the way it works. So the parties are part of the process of selecting who's going to decide the dispute from the beginning, when the contract is drafted, which is very important, all the way through getting a list of potential candidates that they can then strike and rank.
Okay, and for the layperson, if you have a contractual arbitration provision that provides that in a real estate case, you want somebody who has 10 years of experience dealing with commercial real estate matters, that arbitrator, in theory, is much more likely to know the law regarding most of the issues. And having dealt with those issues, they're familiar, and the arbitrator can cut through it maybe a little bit more than a judge who may not really know a lot about various commercial real estate issues. And you've got to brief every single issue, and educate them, where somebody who's sophisticated as a trier of fact with these kinds of things, or as a litigator understood them, it can actually make the arbitration less expensive and more expeditious for the litigants.
Well, yes, a couple of things. One, there are, for example, retired judges who have significant expertise in commercial real estate disputes, or whatever the subject matter is. So simply because someone's a retired judge doesn't mean they don't have the expertise.
Mm-hmm.
But you can pick somebody who has the relevant expertise. And I think what happens is, whether it's a retired judge or a lawyer, whoever the arbitrator is that you select, if they have that relevant expertise, you can gain the one thing that's most important to any litigator in any litigation, which is predictability. Because you bring someone into the mix who understands how certain types of deals are structured, or how they work, and how the different roles in a transaction are play out as the transaction unfolds.
Okay, that's very important to know. And I think that it is important for people to know that they have the freedom to actually choose in advance how that goes. And again, as you say, whether they want uh, one arbitrator or a panel of arbitrators. Now, also in that vein, in court cases, you have a right to appeal an adverse ruling against you. And depending upon the state you're in or the system, you could have two appellate courts before something gets final. In arbitration, the general rule is it's just final, isn't it?
Yeah, so that yes, and there's a little more. Um, you can choose in an arbitration provision to permit one appeal or more appeals. You can even agree to permit appeals in state court if you want, but it's very unusual to do that. So you do get finality because even if you permit an appeal, you get the one appeal. In state court and sometimes in federal court, as I'm sure your listening audience knows, sometimes cases go on for 10 years or more as things get appealed and come back down and get retried, or specific issues get retried. So as a general rule, arbitration does result in a shorter timeline with finality. And I think that that's a safe statement.
Okay, and again, litigants get to decide that in advance. It's
Correct.
not in the middle of trial. Hey, what do we do? It's you guys bargain, or the litigants bargain for the absence of an appeal or an appellate process, and the default rule being that there's no appeal.
Correct. And for those people who are listening who want to know how to construct an arbitration provision, the website for the entity that I work at has a rule building part on their landing page. It's www.jamsadr.com. And if you click on arbitration clauses, you'll see for different industries, they've got different choices, and you make choices along the way. You're not limited by what's in those provisions, but they're very well crafted and pretty thorough.
That is helpful. Speaking of that, and speaking of arbitration provisions, which of course we're not giving legal advice today, but whether it's the selection of the arbitrator or whether or not there are appellate rights, you mentioned discovery. So for, again, people who are non-lawyers, there's a lot of discovery that can go on in litigation, which I guess, help me here if I misstate this. Simply put, it's figuring out what the other side's case is. And is that right?
That is correct.
Okay, and there's a variety of things that may happen in courts, whether it's written questions, I think you call them interrogatories, or requests for admission, or depositions, or document requests, and even subpoenas of third parties to get documents or depositions. All of that in a particular case could make a case unbelievably expensive. Is that right?
Yeah, I mean, discovery is the most expensive part of most large cases, and it could cost millions of dollars, especially electronic discovery. We have to host, we call it ESI, electronically stored information, with a third party, and you can have millions of emails in a case, and you have to hire people to review the documents. One of the things that makes arbitration more efficient is that you get to decide when you draft the arbitration provision how much discovery will be permitted. And the parties can agree to it. And if somebody doesn't like the situation and thinks they need more discovery despite the agreement, they can always apply to the arbitrator. But the arbitrator's first reference will always be, what are the terms of the arbitration agreement? And they would have to make a strong showing to go beyond it. So you are correct. It's a strong arbitration provision with streamlined rules for discovery is one way to reduce a significant cost of litigating a dispute.
Okay, and in theory, one of the things you said before, it's really subject to the creativity of the attorneys or people who draft the arbitration provision. But in theory, you could say one deposition per side, or 5 interrogatories per side, or no expert witnesses, or things like that. And you could, again, you could limit the discovery, make it cost effective. Maybe you could have something in an arbitration provision about a deadline for all discovery in advance, like it all has to be done by a certain point in time, things like that.
Yeah, in fact, the JAMS rules call for all of that stuff. And so if you simply cross-reference the JAMS rules in an arbitration provision, it would all be included. So the answer to your question is yes, and it's not too complex to achieve that goal.
Okay, and you could have more discovery than the discovery that might be in the JAMS rules.
You can agree to whatever you want to agree to. For example, if you have a contract that involves something very technical,
Mhm.
and you're concerned that if there's a dispute, you'd like to arbitrate it because you don't want the IP out in the public domain, but you also recognize that because it's very technical and complex, you're going to need to take several depositions. You can certainly agree in the arbitration provision to anything you want. One of the easy defaults is to permit discovery according to the relevant state's Code of Civil Procedure or the federal rules of civil procedure. And then under that scenario, you would get the confidentiality that comes with an arbitration, but the access to full discovery, if necessary, that type of contract.
Understood. So again, that obviously makes the litigants more comfortable. And I should clarify, we've sort of been talking, people might assume that if I had a contract with you for something, for you to provide certain services to me, we can have an arbitration provision. But if the contract didn't have that provision, but there was a dispute and the party said, hey, do we really want to go to court and deal with this? You could then come up with an agreement after you've entered into the contract, even after you've had the dispute, to try to arbitrate. Isn't that right?
That's right. You can always agree to arbitrate even after the fact, and even during the existence of a live case in state or federal court. The parties can always agree to arbitrate. It's not all that common, but it can be done.
Okay. And then let's say we get past all of the discovery and we're talking about the hearing. If there is no provision in the arbitration agreement, I presume most arbitrators are going to say, well, we're going to have live testimony and you're going to submit your documents to me as the arbitrator so many days in advance, and there'll be a procedure to object to the admission into evidence of the documents and stuff like that. And the arbitrator would conduct the hearing fairly similar to a trial, except no jury. Is that what the default would be?
Yes and no. So the arbitrator would conduct the hearing. It would, if the parties didn't agree that it could be virtual, it would be live.
Mm-hmm.
The arbitrator can let anybody the arbitrator wants testify virtually, which is, as you know, more and more common. The documents, where it differs dramatically from a state court trial or a federal trial, is the rules of evidence don't apply. And what that means is that pretty much all of the documents and testimony will get into evidence, but the arbitrator will consider the weight of the evidence based upon the credibility of the document.
Understood.
So for example, really quickly, if there was a document that couldn't get into evidence in state court because it's considered hearsay, which I won't bore your audience with, as an arbitrator, I would let it in. But if the hearsay rule would make the document perhaps less reliable, I would consider that as well.
So you have latitude as an arbitrator as to how you deal with rules of evidence and how much you're going to weigh a particular document, whether it's authenticity or whether it has, again, hearsay in it or what have you.
That is correct.
Okay. And also parties could limit the scope of a hearing by contract, right? So that they could say no live testimony, or 2 hours for each side for live testimony, or only cross-examination, or have a hearing just based upon the briefs, the legal briefs that are submitted to you, and then you as the arbitrator would decide based upon what the parties agreed to. Is that right?
That's right. The most common of all of the examples you just listed was to submit the matter on the papers. Because there are some cases, I'm sure you can imagine, where the testimony is really just talking about the documents, and sometimes the litigants make the decision together that it's not worth the cost of trying the case when they're going to be submitting the documents and briefs anyway. So you are correct. It can be however the litigants want to structure it. However, if there is no agreement, it all defaults back to the rules.
Understood. But and there could be like amazing things like baseball arbitration, the high-low, the arbitrator picks one. Again, as you know, the operative thing I think for the audience is it's subject to the creativity of the people drafting the arbitration provision and what they think makes sense when they're deciding to do business.
That's right. That is exactly right.
Now, one thing that is subsumed in this that I think, because we've been talking a lot about contracts, in theory, you could arbitrate an injury case, which a lot of, I think, my recollection is a lot of plaintiffs don't ever want to waive a jury trial. But in theory, again, it's not limited to purely contractual disputes, like you said.
That's correct. If there is no contractual agreement to litigate an issue, both parties would have to agree to it. That said, there can be arbitration provisions that would include a personal injury type claim. For example, an employment agreement might include everything that could happen on the job site, contractual, tort, or otherwise. But for the most part, it has to be derived from the contractual agreement to arbitrate.
Okay. Now, with that, because I think we've done a nice job canvassing arbitration, let me just ask you, are there any downsides other than what we talked about before, like, waiver of jury trial, et cetera? Are there any downsides really to arbitrating?
The only difference in terms of downsides is with arbitration, the parties have to pay the arbitrator. With state and federal court, the taxpayers are paying the judges. Now, my view is that arbitration is so much more efficient that it ultimately costs less to pay the arbitrator than to have full litigation in state or federal court. But that is something that people have to be aware of, is that they're going to have to write a check in order to pay the neutral to review the case. And if it's a panel, you're paying for 3.
Understood. That makes sense. And otherwise, if you like the privacy, if you like the customization of it, if you like the idea that you can limit discovery, if you like the idea that you get to pick who the trier of fact is, arbitration can be a pretty good place to be. And also, again, to the extent you don't want the matter public.
Right. With one other footnote, also remembering that the rules of evidence don't apply, so that could cut both ways.
Understood. And I suppose each litigant, when you're drafting a commercial agreement, you may not fully focus on that or appreciate the nuances because you don't know what the dispute's going to be.
That's exactly right.
Thanks for tuning in. If you want more info on the show, please visit blockandtackleshow.com. And you can also email me at carl@blockandtackleshow.com. Thanks for tuning in.